good evening, good afternoon, good morning, good night, wherever everyone is. I see the room filling up. The number is going up steadily. We're very excited that so many of you registered for this evening, at least this evening, my time. Welcome. This is a part of the London International Disputes Week. I actually, for those who are not in international law, who are not lawyers, it's funny that we talk about international disputes because maybe they think that we're going to spend a week fighting, but obviously it's London International Dispute Resolution Week, an event that is organized by CEARP together with Queen Mary and also the Young Canadian Arbitration Practitioners. So this is a team effort globally. Let me start this evening. We only have 1 hour to go. We're going to go Dutch because I am Dutch. So this means that on the hour, we're going to stop and we're going to sign off. It's also Dutch in the sense that you are at home. We're not buying you drinks. You have to do it yourself. So what are we going to talk about? It's the future of dispute resolution training. And those of you who are students, those of you who are professors, I think all of us have Zoom fatigue, and now we're adding another hour to all of those Zoom meetings and Zoom webinars. So we're going to try to make it exciting, dynamic, and throw in some jokes, some acts, God knows what have you. So what are we going to talk about? What's happening in the world today? What's happening in the world of international arbitration? We have technology, we have diversification. What does that mean? Already 10 years ago, the father of international arbitration, Professor Peter Sanders, said, I predict that there's going to be a diversification of arbitral seats. It's no longer just London, Paris, Washington. You will see arbitral seats popping up everywhere. This happened in the last decade. What does that mean for students and young lawyers? What does it mean for older lawyers, right? We can't discriminate. We see a prediction of the future that has become our present, which is the virtual world of international dispute resolution. We see the rise of technology, artificial intelligence, blockchain. We see new developments in how we have to resolve disputes, which is mediation, and Martin Hunter refers to third-party assisted amicable settlement. And then 2020 throws us into the global pandemic. And we were just catapulted in this world of virtual hearings, and none of us really were ready, right? Because lawyers, at the end of the day, we don't like change. So the question is, we are here, and was education going at the same speed? Are we changing along, us academics and us in education and us at universities and those at the bar and at CEARP? Are we changing at the same pace? Are we ready, or is there more that we need to do? Now, we're going to talk about that with a group of specialists. What's really great about this evening is that the speakers in the room, whom you can see on your screen, have so many hats. And I'm not going to get into double hatting because that's the hot potato, but our speakers are wearing multiple hats. I'm going to introduce them in a second. Now, I see 150 participants, 152, numbers still going up. So we want this not to be a presentation because that's already boring in real life, but over Zoom, it's just not doable. So you can ask questions, not by us seeing you, because that's not what a Zoom webinar does. You have to put something in the chat or the Q&A, and I'm going to allow my brain to multitask and look at the chat and look at the Q&A. At any time, if you have a burning question or you have a remark or criticism or something else that you want to share, just throw it in there and I'll try to pick up on it if I like it. And so that's going to be the dynamics of the hour. The speakers will not give presentations. They will enter into a conversation with each other and with you, although we can't see you, but you can see us. So who are the speakers? We've got 4 speakers this evening, 2 women and 2 men. So that was what we call gender equality. I'm going to start with the ladies first. We have Nadja with us, who wears the hat of the client, but previously the user. Previously, she was also in the field of law. So she has seen how the sausage is made and how lawyers tailor to and service their clients. And she is now legal counsel with Barrick. And those of you who are in the field of arbitration, I'm not going to explain who Barrick is because you should know. And she is very much focused on Africa and the Middle East, where incidentally I am based. And as we all know, in the world of investor-state dispute settlement, Africa is quite an important region. And we're all here to maybe help Nadja find more amicable ways forward. Then we have Alexandra, who is based in Canada, who wears so many hats that it took me a while to study her resume, which is what we love to see, right? Strong women on the rise. Alexandra is in the practice of law, not just arbitration, but also litigation with respect to arbitration. It's both domestic and international. She has been named as a future leader and a rising star. I would say she is already a leader and she is already a star. And at the same time, she also wears the hat of professor because she's an adjunct professor on CITPRO, respect for that. And this is where I was really, my brain tried to follow it. She's also the director of the Vancouver International Arbitration Center, which means Alexandra does not sleep. That's how busy she is. Then we have our two gentlemen. We have Remy, who also has many personalities and many hats because he works at a law firm, Moeller Lamken, in the US, but Remy was trained in the US, UK, France, and Switzerland. Now, I respect that because I'm a trained civil lawyer, and the minute after 10 years that I was learning about common law, I was incredibly confused and said, I just can't think as a common lawyer. So I'm very interested how you can think both as civil and common law. It's a very unique trait, and I'm very impressed with that. Remy is not just in the practice of international dispute resolution, but also with Queen Mary, where he has a permanent academic position. And he is the co-director of the LLM in international arbitration. Again, I don't know how you do it, but you do. And previously he was with the LCA and DFC, and he sits as an arbitrator. So Remy basically wears every single hat. And that means that whatever questions we need answering, they will be answered this evening. And then last but not least, we have Paresh with us, who is here on behalf of CERP, and he's actually the director of education and training, and that's what we're talking about, right? And CERP is doing amazing courses and skills training. I've had the pleasure finally to be part of it. It is very impressive, and this is what we need because it's skills training that we're going to talk about. And previously, Paresh was also in academia and is an expert on artificial intelligence and technology, and that's where we are in the present and the future. So let's kick off with our topics. So we talk about education, we talk about how does education need to evolve. And so we decided, well, where do you start? You start with the users, right? So we start with what the user wants. So what is the user in this case? Well, that's obviously the client. I mean, why are we learning about international dispute resolution? Because at some point we want to become lawyers to work for clients who make use of this system of dispute resolution, or we act as arbitrators to adjudicate those disputes. Then the second, what is what the user wants and who is the user? It's the bar. So what we see in the United States, where I spent about a decade, is that American students, JDs and LLMs alike, they're very focused on the courses that they need to take to get them ready for the bar exam. Not only that, but also if you want to do New York bar, Florida bar, what do you need to do? And sometimes law schools try to work with the bar to see, okay, how can we find a common ground? So no pun intended, but the bars, they do set the bar. So let's start with the user perspective. I want to give the floor to Naja, who is a user. My question to you, Naja, is you see this new reality of a global pandemic, nationalism, virtual hearings. So our question is, and everybody wants to know, what would you want to see maybe done in a different way? And how do you think professors and organizations like CERP need to tailor to that new reality? Over to you, Naja.
Thank you so much for your kind introduction, Marika, and hello, everyone. I'm delighted and honored to be part of this tribunal. So I worked in arbitration prior to moving in-house, and when you are working or studying arbitration, there's very much focused on trying to get to the arbitration, right? You need to get to that hearing, you're trying to get that award. But things change once you move to the other side as the client, because as much as we know how useful an arbitration award can be from a commercial point of view, an arbitration award is, first of all, it's very time consuming, it's very expensive, and you still need a business to run. Best case scenario, it's going to take 2 to 3 years for you to get that award, and then who knows how you're going to enforce it. So one of the things that I would like to see is a little bit more focus on negotiation and mediation, training lawyers how to negotiate, the strategic importance of mediation, um, and how mediation could be developed. Because we all know that when you study ADR, if you're doing an arbitration focused course, it's all about, well, yes, there's mediation and there's negotiation, but because they're not binding, and you have this enforceable award at the end of the arbitration process, it's commercially more sound to go for the arbitration process. But I've been looking at a lot of developments on mediation, which are quite exciting. There's the draft ISDS mediation rules, the Singapore Mediation Convention that I've been reading about. I don't know whether actually it has been used in practice. I don't know of any real life examples where it has been applied. But I think that focus on negotiating strategy, mediation agreements would be very useful, because we're trying to avoid getting to that arbitration or to the litigation stage, because you're also trying to maintain that business relationship that you have with your client, particularly if you have a long-term project, or if you're working with a state in a capital heavy investment industry, such as the extractive industries, mining, oil and gas. These relationships are built that are supposed to last 10, 20, 30 years. And starting arbitration could destroy all of that. And by that time, both parties would have invested a lot of time and effort into that. One of the other things that I think would be really useful, particularly in the pandemic, what I've noticed is that a few times when we've instructed lawyers, and they have trainees who are coming to learn, not all of them had a sound commercial background. And that's not their fault. If you're 20 years old, you've just finished law school, you're doing a training contract, you've just entered into a law firm, and you're being asked to review complicated financial statements or to do costs analysis, it can be quite daunting. So I think it would be very useful if in law school there was a little bit more of a focus on business skills, particularly financial literacy, statistical analytics, picking up on patterns and things like that. It's very useful, and it could be used quite strategically in negotiations. So rather than saving it for when you're filing your submissions or where you're starting your arbitration, these sort of skills could actually help the parties look at a dispute from a different view and reach a conclusion to that dispute without it actually having to escalate, thus preserving the relationship between the parties and saving everybody a lot of time and effort. Not ideal if you're a disputes lawyer, because I know that ultimately you want to get to that courtroom, or you want to get to that arbitration hearing. But from a business perspective, the most successful dispute resolution is no disputes.
Well, you know what? A happy client, Naja, is a client who comes back. And I think we all need to understand we want happy clients. We don't want clients who we sort of keep close for years and years and years. That's not how this works. So I'm going to improvise as we go, because this is a very interesting angle on mediation. There are quite a lot of questions in the chat on mediation. So my fellow speakers, we're going to go with the flow here. There are a lot of speakers joining us from all over the world, close to me in Bahrain, India. Welcome to everybody. This is really amazing. Obviously, all our prayers are with our friends in India. This is heartbreaking. Great to see you here. There are questions about mediation and arbitration. One is a quick one that I'm going to give, which is, what is the difference between mediation and arbitration? And Naja actually gave it away, which is mediation is amicable. Mediation preserves the relationship. Mediation is one that you come to a solution in a way together with the help of a third person, third party, amicable assisted settlement. Whereas with arbitration, you're breaking up. You are breaking up. So I just want to give the floor and about commerce, and I want to also hear Ramiz's views on this. We actually, when we were with Miami Law, really wanted to get a professor to teach international business transactions. When I worked for Abraham Vandenberg, he said, you need to do finance for lawyers. And somehow, as us in academia, we miss it. We don't do it. So Remy, I have three questions for you, actually. The first is, how is it that we have that gap there of sort of, aligning the sort of theoretical world of academia with what users want, which is business and finance. And for example, with Queen Mary, where you are there any plans of adding mediation courses? Could you just tap into those, and then we go into the experiential, I can't pronounce it, experiential learning. Go ahead, Remy.
Of course, I think Nadia is making a very good point about the what of teaching, what we should be teaching. And I think having a more holistic approach to different aspects of ADR is pretty crucial. At Queen Mary University, we have a School of International Arbitration, which has been around for some 35 years. But at the School of International Arbitration, we also teach mediation and ADR. One of my colleagues, Debbie De Girolamo, is a mediation expert, and that's all she teaches. We also have other classes on strategic decision making for lawyers, and so we're trying, to integrate this holistic approach to dispute resolution. But I think Nadia is entirely right that we're still teaching in silos a little bit. When you do an arbitration course, you really study arbitration typically, and we don't really study med-arb, for example, or arb-med within arbitration as much as we should. So I think that's a very good point. And so, but that's the what of teaching. There's the how as well. How we teach. Can we teach differently from and depart from our traditional lecturing formats? And so, Marike, you were talking of experiential learning. I think it's a great topic, and I think the starting point here is that legal practice has changed quite dramatically in the past 20 years with the advent of the internet and technological innovation. And so while 20 years ago, there was perhaps more of an emphasis on legal knowledge, on knowing the law, I think it's fair to say that today there's more of an emphasis on legal know-how, on skills, on how we use the law, simply because knowing everything there is to know about Prima Paint and Mitsubishi Solar or Dow Chemical, all of these classical cases in arbitration is not incredibly helpful if you're able to find that information on the internet in 5 minutes, right? So that should be more of an emphasis on the skills, if you want, and therefore legal education should have shifted a bit more than it has, I think, towards experiential learning. And it's happening, and I'm sure the other panelists will have much to say about it, but my feeling is that we're very slow in moving there. And in America, it happened, there was all sorts of experiential learning over the years, but things really accelerated massively after the financial crisis of 2008, 2009, if you remember, where all of a sudden the law schools were facing tremendous financial pressures because students didn't want to study law anymore because there were no jobs in legal practice, right? So for a short period of time, these struggling law schools embraced the problem, and they really took a hard look at their curriculum and how they can change the way they teach in order to satisfy the needs of the clients, including Nadia and the big companies. And so what they did is they exchanged with law firms and in-house lawyers, and the message was very much that the schools had to equip their students with more skills. There were talks of scrapping the third year of the JD program. Some law schools replaced it by experiential learning. And so we moved in that direction. What happened in practice is really that there's been more in the past 10, 12 years in America. There's been more workshops, of course, or simulations that take place in a traditional classroom environment. There's been, of course, more emphasis on mooting. But two other developments that I think are really interesting is the increasing use of externships, where basically students are given an opportunity to do an internship with a law firm or company, and they're getting credits as if they were taking a class back at the law school. And of course, these are, these internships take place in a strict framework, but it works very well. And the final point, which I think is most attractive or intriguing to me, is clinical legal education. And by legal clinics, what we mean is effectively a small law firm within a law school where law students are going to work under the authority and supervisions of qualified attorneys on real life cases. So they're going to write submissions, they're going to engage in oral advocacy on real life cases, which are pro bono cases. This has been going on for a long time. It really exploded in America in the 70s and 80s. But we're talking, until recently, we've been talking mostly of immigration law, consumer protection, healthcare law, labor law, etc. But I really think there is room for clinical legal education in international commercial arbitration, where I think we all know as practitioners and arbitrators, there's no shortage of cases where you have claimants that are distressed claimants. They have perfectly valid claims, but they perhaps don't have the liquidity to pursue a lengthy and costly arbitration. And so it'd be very interesting to see if we can, going forward, develop clinical legal education for international arbitration, perhaps with the supervision of law firms, of institutions like the Chartered Institute of Arbitrators. But I think there's room really to go there. So that's the idea I'm throwing out there, and hopefully it will happen sooner or later.
Thank you, Remy. So this is very interesting because I see in the chat and the Q&A, there are many questions now about mediation versus arbitration, mandatory negotiation, in that you add those clauses to contracts. What should we do from a training point of view, mediation or arbitration training, which qualification is more popular? So there's quite a focus in the chat and the Q&A on, if we want to enter this world of, or grow in this world of international dispute resolution, should we now maybe shift our focus to getting trained as a mediator? And Alexandra, before I go to you, I want to go to Paresh on a couple of things, because I guess really the question out there is, would it be fruitful that new entrants or those who might want to, change pathways to take courses on mediation? Now, Queen Mary already offers courses on mediation. My question would be, well, is it important to focus on the what? So what courses am I taking? Do I need to learn mediation? Do I need to learn arbitration? Do I need to learn about contracts and negotiation? Or should we focus on the fact that an institution like CEARB teaches about all the building blocks, like you did earlier in this year with the whole group, teach all the building blocks, but then really focus on the skill set. And at the end of the day, the skill set for acting as an arbitrator where you adjudicate, or acting as a mediator where you bring parties together, they're very, very close. So my question to you is, what would your recommendation be? Would you advise those who are now attending, okay, you know what, add a mediation course, add a negotiation course, or would you say, focus on more skills-based training, get out there, like Remy says, do those moods, work with law firms, and just see how the sausage is made, and do these practice rounds? Like, what should they do? Paresh.
Thank you, Marika, and it's a pleasure to be here, and welcome all. So this is an interesting question, it's a very timely one, because at the moment we're going through a reform of our education and training provision. And one of the things that we're currently focusing upon is developing ADR professionals, and then on top of that, and working on what skills and what knowledge arbitrators and mediators need to know. So we could, for example, pitch ourselves at of course, developing arbitration and mediation training, but we strongly believe that there's a step before that, which is what makes a common ADR professional? What skills do all arbitrators, adjudicators, and mediators need to know from an ADR perspective when it comes to dispute resolution? So I think the answer to your question lies in not, of course, there'll always be people who want to be arbitrators, want to be mediators, want to specialize in both disciplines. But I think there's an important step before that, which is, first of all, what's a dispute and how does one resolve, how does one avoid it? And that, understanding what a dispute is and what skills are required to resolve, avoid disputes, is something which is, of course, common to all the disciplines. And it's developing those skills at the beginning, and imparting those skills which can then be used to go on and further specialize within arbitration, adjudication, mediation, should someone wish to do so. So, for example, we're working on a competence framework at the moment, and the beginning of our competence framework in ADR is identifying those core common skills of all ADR professionals, so that people come to CIRB as the home of ADR and develop those skills, and then go on to look at the disciplines and specialize in those should they wish to do so. And I guess that today, with different forms of technology, with ODR, with online dispute resolution, different forms of resolving disputes, I think the world of ADR is changing. and we're seeing new people, new professions enter, alternative legal service providers who are introducing new forms of technology. So I think that the question to be asked is whether arbitration, mediation, whether those sort of discrete disciplines will, of course, they'll always remain there, but the way in which they'll come together in a complementary form, how they'll sort of feed off each other. For example, Med, Arb, Med, and how they'll sort of mix with technology will be important, so that in the future, the dispute resolver of the future won't be looking solely at just arbitration, mediation, and dispute resolution. They'll have a spectrum of different ways in which to resolve disputes, and then they can pick and choose and specialize in different ones, because ultimately the focus is upon dispute and how to resolve those. And in the future, there'll be many different tools and ways of doing that.
Thank you. I think what's really important, not just for us professors and the leaders at institutions and universities, if you listen to Naja, I think one judge in the United States said to me when we're talking about a political and policy problem in the US, she said to me, just listen. And I think it's very important to listen to Naja, because she put that out there on mediation. I've heard colleagues of Naja say it, they go to the board. They look at those relationships and those investments in a different way. And for those who are asking the questions now, so there are questions about would a multi-tier dispute resolution clause, would that work? Now, I've seen in practice when I acted as an expert that it does not work, because there's so much confusion with respect to interpretation. I think we need to be far more sensitive to what do the users who are out there in the fast lane of international trade, what do they need? And we see now it is mediation. And I think those of our generation are not entirely ready for it. So let's now move to another key development that you already touched upon, which is technology. And I already saw a question in the chat about blockchain. So we have blockchain ADR, developed that in Miami. The ICC was very interested. Martin Hunter said, what is this? Are these blocks connected by chains? And it's very hard for us, the old professors, to understand what a blockchain is. But it's out there, ADR on the blockchain, and it's actually more secure, and it's in a way cheaper, and it's authentic, and you avoid problems with the New York Convention. But when we developed it to address that question in the audience, we thought we'd take it at a slow pace, and in comes 2020 and the virtual hearings, and many of us are quite lost. So let's tap into that with Alexandra. The key developments in dispute resolution and just in the world since 2020. I talked about the diversification. So we see seeds, here in the region where I am, in Dubai and in Qatar and Saudi and Bahrain and Africa and India, et cetera, et cetera. That changes the landscape. We need to understand from Naja, well, would they want to opt for a different seat? Why would they still want to go to London when the dispute and the investment is actually in Africa? We just talked about the technology, we talked about mediation, and then there is where we are now, the world of social media. So one question that Alexander will address for the audience is, how does the new pool of up and coming arbitrators, lawyers, service providers, mediators, how can they use that social media and all the below 40 groups to rise through the ranks? Now, before I give the floor to first Alexandra and then Remy, and perhaps a bit about artificial intelligence and technology, for those in the audience, the question over the last year has been raised almost at every single webinar in international arbitration about virtual hearings. So we've now spent, I would say, a year, all of us, hopping from virtual hearing to virtual hearing. We all know how that is going. It is working. It allows for parties to continue with their arbitrations, but it's also complicated. So one question that then arises, what is that type of arbitration? What is a virtual hearing? Where is the arbitration? Well, that's a non-question, right? Because the seat is still the seat. What is very ironic, we're thrown into this in 2020 when Gerald Herman, one of the sort of the leading figures in international arbitration back in the days, said in 1999, he said about awards and where is the award effectively rendered, while a national, he's being very cynical, while a national or free-floating awards are more common in the imaginative world of radical delocalizers than in the real world, we may wish to anticipate future space awards rendered in cyberspace, called Virtual Cybitration Awards by seatless online arbitration centers, or in outer space arbitration by the Galactic Arbitration Center. Now, 4th of May was the Star Wars Day in the United States. May the force be with you. But the irony is that we've just spent a year of virtual hearings. So Gerald might have been making jokes, but here we are. So that is something we need to talk about today, is what have we learned so far? I'm sure Nadja will have some feedback, as in I would like to see this differently or just skip hearings altogether. But before we go into that virtual space of arbitration, I want to give the floor to Alexandra, who has been very much involved in these below 40 groups. The way we got jobs is very old school. You type a letter and you send that by mail to a law firm and you have an in-person job interview. Whereas today, people build their networks and build their profile through all the social media, and there are so many below 40 groups. And the question that arises a lot, and we talked about it in preparing this discussion, is there are now many people out there who want to start as an arbitrator. So Alexandra, what are your views on that? And what are your, do you have a bit of really valuable advice that you're going to give out for free today for this audience?
So I think whether you're in law school or whether you're out of law school, and whether you want to be counsel or whether you want to be an arbitrator, it's to your benefit to join and get involved in the under 40 groups. And they exist internationally and they exist regionally. So some of them include the ICC Young Arbitration Forum, there's Young ICA, there's Young ITA, there's the LCIA's Young Group YAG, and so on. There's a number of them in Europe as well, such as CF40, I think. And so there's a number of them, no matter which country you're in, no matter which continent you're in. But what they allow you to do is they allow you to build your professional network when you're first starting out and to connect with your peers. And if you stay in the profession as counsel or as an arbitrator, and you and your peers move up in seniority, eventually your peers are either going to become referral sources for you, they're going to become clients eventually and go in-house, or they're going to be either arbitrators or you're an arbitrator and they're going to potentially appoint you. So making these connections as early on in your career as possible is going to be important no matter which track you take. And on top of that, these groups put on continuing education conferences, and many of them do skills-based hands-on learning. So they'll do cross-examination workshops, opening statement workshops, written memorial workshops, how to work with experts, how to cross-examine an expert. And they'll often have senior practitioners come and give those seminars, and they're often done for free if you're a member of those organizations, and many of them are free to join. And so what this does is not only allows you to practice your skills in an environment where there's low stakes, it's not an actual real file with real client, but it also allows you to keep relevant on hot topics in the law and recent developments in arbitration. So any changes that arbitral institutions have made to their rules, any groundbreaking cases that have happened, the whole debate around virtual hearings, those kinds of things are dealt with in these kinds of seminars that groups put on. And so I would encourage everyone who's starting out their careers to join both a regional and an international group at the very least. And lastly, what these groups can do is they can also present speaking opportunities for you as a young practitioner. And they also often have blogs that you can publish to or a journal that you can publish to. So it allows you to raise your profile fairly early on, which again is going to be to the benefit of whether you want to be an arbitrator or counsel. And I think for most people, this changes a bit by jurisdiction, but for many jurisdictions, you have to start out as counsel, get some experience as counsel before you can pursue a career as an arbitrator, because people aren't going to want to hire you as an arbitrator if they don't know that you have a track record of a certain experience in different kinds of disputes. And similarly, as counsel, it can make you better counsel to do some arbitrator neutral work. So they go to some extent hand on hand at the beginning of your career.
Thank you. I'm multitasking here, also following the Q&A and the chat. And luckily, we're getting support from Lucas and others who are, while we're speaking, also giving answers to the many questions in the chat. So thank you for that. This is incredibly helpful. There is a question to us to maybe at some point provide a list of the below 40 groups. Now, I know that you can go to the Young ICA website. Let me just type Young ICA here.
And Marika, I see one of the questions, maybe just to answer it quickly. So most of them are free to join, and there's no admission requirement. I saw that as one of the questions. You simply have to sign up to join and indicate whether you're a student or you're practicing or you're continuing on in academics like a professor, or if you're working for the government or whatnot. And then you're automatically a member, and you get email blasts or LinkedIn blasts about events, and it's kind of up to you for how involved you want to get. So whether you want to help organize events and then kind of make your way up to joining the board of those events eventually, or the executive.
Exactly. And the good thing is all these groups are really in a way connected. So with Young ICA, what we did at the time, we made a full list of all the below 40 groups, also a list of all the universities, a list of all the scholarships. There are many scholarships for Queen Mary, for Geneva, for Miami, you name it. There are mentorship programs, there's training. And one advantage of the virtual reality that we live in is that you can now participate through Zoom. And I think many of us professors are now saying yes to teaching invitations that we normally would say no to. So we can now teach in so many regions because we don't have to travel. So what I would do is Google all those things that you now see in the chat, like Young ICA, WIAC, and you can take it from there. And all these groups now also have social media groups. And this is a great way for you to find a way that those doors are opened. I now see a remark. I just wanted to share. Yeah, go ahead.
I was just going to add, Marika, before we switch topics, that one thing that's great about Young ICA is that they have a mentorship program, which is another way of learning, beyond, the classroom, the professional trainings, the young groups. And mentorship is very important to learn about the practice of international arbitration. And Young ICA is, as far as I know, probably the only organization that really has such a nice structured, mentorship program. So a good reason to join Young ICA.
Well, I'm blushing because that was my baby that I created in 2008, and I could never have predicted that it expanded the way it did. So there is a remark that Young ICA wants you to write a motivation letter. Now, let me explain that. When we created Young ICA in 2008, the idea was indeed, because I saw with the below 40 groups in Europe that it was a little bit of the same exclusive crowd of big law from London, Paris, Amsterdam, and what have you. And I thought this is not the way the world should be. So we did Young ICA, and we said, this is not about networking, it's about training that needs to be available to all, no matter where you're from, and mentorship so that I can have students and young lawyers from developing regions who can be teamed up with the leading arbitrators in, let's say, London. Now, we created then a scholarship, and for the scholarship, we needed an essay contest, but the mentorship program grew to a point where we had to ask these motivation letters. So I apologize for that, but the success at some point was kind of working against us, that we could not accommodate everybody in the mentoring program. And so that's why we did that. But what I will always say to young protégés who come to me saying, like, I didn't get in, try again. And also, we are all there to help you. So you can reach out to me or any one of us, and we will actually take the time to help you and open those doors. So these young groups are fantastic. Now, I still kind of, before I go to Paresh and Naja, I still want to go back to Alexander, because there's one elephant in the room, not only on my wall, but also in the room, which is, when you and I started, and Remy, I think when I started, I just thought I'm going to be a lawyer. It never occurred to me that one day I have to be an arbitrator. Now with almost all my students, I see they want to sit as an arbitrator. Alexander, what is your take on that?
So, I think when international arbitration started as a field, there was much less competition to become an arbitrator. If you spoke a couple languages, were called in a couple different jurisdictions, it was fairly easy to make your way up to becoming an arbitrator. The market has become so much more saturated now as an arbitrator. And when you're sitting in a firm, if you're in a big law firm, you're going to run into all sorts of issues with conflicts that arise because you're meant to be neutral. And so your firm then can't take on representation for some of these large clients as counsel after. And so there's a bit of butting heads that started happening now with arbitrator practices, where more often they're going off and practicing on their own rather than remaining in a big firm. So I think it depends. Again, I think everyone should start off as counsel to get that experience. And then where you go from there depends on what gets you excited and what gets you up in the morning. For me, I love being counsel. I love taking a position and arguing a case. I love working with witnesses and prepping them for their cross-examinations and putting the story together of what happened. I like the presentation and the advocacy that you get as counsel. All of that you don't get as much of as an arbitrator. You do a lot of listening and you do a lot of reading, but less kind of interacting. You don't have a client in mind. So I think it really depends what it is that's going to get you excited when you start practicing. But I am surprised at the number of people who want to be arbitrator this day, because I think there's also a very profitable practice to be counsel in international arbitration.
I agree. Remy, do you have any reactions to that?
Yeah, I think it's entirely right, Marike, that every single year at Queen Mary, we have students, young students, who approach us and ask how they can become arbitrators, and they have not yet had any experience as counsel in law firms. And it's always a bit heartbreaking to tell them that it's going to be difficult to be appointed arbitrator before they gain enough experience as counsel. The question is logical, because in some jurisdictions, in some civil law jurisdictions, when you finish law school, you have a choice of becoming a judge or an advocate. And then you keep that career for the rest of your life. So people assume that you can just be an arbitrator for your whole career. I think in the vast majority of cases, you need to have obtained enough experience as counsel before people or to parties, counsel and institutions will want to appoint you, because they will want, as Alexandra said, to know that you are a safe pair of hands, right? The nuance I would give, though, is that there's no one path to becoming an arbitrator. We know that some arbitrators are non-lawyers, albeit non-lawyers often with extensive experience of dispute resolution, whether they're quantity surveyors or other professions. So that's one thing. Another one is that today you can gain that arbitration experience by doing different jobs. You can be in academia and become an arbitrator later on. You can do a bit of time in a private practice, then move to an arbitral institution and back to academia or whatever. So there's different ways to get there, but the constant, I think, is experience. Nobody's going to want to appoint you, whether they're parties, outside counsel or arbitral institutions, if you can't show to them that you're going to be a safe pair of hands.
And also, Remy, I mean, this is really so true. When we look at diversity and gender equality, there has been a real push to, expand the pool of younger people, more women, and sort of say, okay, we have that generation that kind of dominated the pool. I'm just going to be the blunt Dutch person. They were called the mafia arbitrators. And again, I'm going to be the blunt Dutch person. No, it's being recorded, but I've said it anyway. It's male, pale, and still. I think I can say that. Silent. But here's what I said. When I was being approached to sit as an arbitrator, I remember I said, and I worked for Albion Vandenberg, so I knew what it meant to be an arbitrator. I said, I'm not ready. I'm not there yet. And the thing is, if you get appointed as an arbitrator at a point in your career when you're not ready, that's going to damage you so much more on the long term. So think about that. And this is the beauty of our field and where we're in. There's so many hats that you can wear. Look at these speakers. Look at how many hats. And this is now the new thing. You can do it as a mediator, as a negotiator. There are all these different pathways. So just keep an open mind. Now, so counsel, thank you so much. Alexandra's already answering those questions. You see, we're all working together, teamwork virtually in the Zoom space. Now, talking about
America, before we just jump in, just to
go
say
ahead.
that as a client, if you have a multi-billion-dollar dispute and you're looking to appoint an arbitrator, you would be very reluctant to appoint somebody who's brand new, just a couple of years of experience. You're looking for, because remember, you're going to be responsible for an entire business. You're going to have to stand up in front of a board of directors, in front of your shareholders, and justify to them why you made that choice and whether that was the correct choice. So I think it's safe to say that more experience is always better.
You know, thank you, Naja. You just dropped the mic, because this is exactly it. In our little world of arbitration, where we go to all our conferences and we stand up and we give our speech of, you know, inclusivity and equality, it's the right thing to do, and diversity is the right thing to do. But when you go back to your office and you're working with your team and you're pitching to clients and you're advising clients, what does a client want? Clients want to win the case. When are the users often not happy with international arbitration? When they lose. You want the best man or woman for the job, and that is how the world works. You need to become a specialist. You need to get those years under your belt. And also, like Alexandra says, and I fully agree with her, is this something you want to do? And so, Naja, I want to stay with you a little bit on what the user wants, because now we have these virtual hearings, right? And everybody is just trying to go along, and the arbitrators are trying to work it out. The institutions are trying to help. Lawyers, when cross-examining the witnesses, try to be as persuasive. There was a question in the chat: is it different? Now you have now been part of seeing your teams, your outside lawyers handling those hearings. Given that there's already a whole written phase, right? Would you now say, I'd rather skip the hearing? What is your take on this?
No, not necessarily. I mean, don't get me wrong. Virtual hearings are great for certain things. And anything that saves costs for a company is very much welcome, because costs are a very big issue once you sit on the client side. So you're always trying to find the most cost-effective way to do it. So if it's a jurisdictional hearing, which doesn't require a lot of witness examination, then yes, absolutely, virtual hearing is the way to go. You don't need to shuffle people along to cover all those extra costs, because normally you have to get the lawyers, the teams, arbitrators, accommodation, flights. It's a bit of an exercise to organize all of that. But at the same time, when it comes to the main hearing, when you have to examine your witnesses, I think this is just my perspective. There's still a little bit of reluctance to go fully digital. You still want to have those witnesses in person so they can be examined, cross-examined. You want to see how the tribunal will react, because one of the downsides of virtual hearings is that you don't actually see how the arbitrators are taking your arguments. The lawyers can't exactly gauge which direction they should be going in. So I think that, and I say that I'm going to contradict myself a little bit, because at the height of the pandemic last year, we noticed that courts, which had the capacity to do virtual hearings, worked great. So for example, in Zambia, in the UK, we had no issues. The hearing, it was business as usual, essentially. But then in other countries like the DRC, Ivory Coast, and Mali, they were shut. The courts were shut for over 6 months, where everything halts and you can't move any dispute. So there are really a lot of benefits to virtual hearings, but I don't think that we're at a stage yet where virtual hearings can completely replace an actual hearing. And perhaps this is also a training point that could be picked up, because if you're doing virtual advocacy, I think you require a different skill set than if you're doing advocacy in person. And I don't think that that's currently in the market yet. I think this is becoming apparent as we go along throughout the last year. But I think that this is something that could possibly become a thing. And who knows, the next generation could be trained to move seamlessly in either world, to conduct a complete virtual hearing or to conduct it in person. So we'll just have to see how it goes.
So thank you so much for that, Naja. Paresh, so what is your answer to that? We are now trying to figure out what are the do's and don'ts of virtual arbitration. How can we still persuade? How can we excel in the art of advocacy? Is CR getting ready for that? Can we expect some courses on the sort of the art of persuasion in the virtual space?
I think the clues in the abstract for this particular session, which is now, I think we're living in a flatter, faster, and smaller environment than what we were a year and a half, certainly before lockdown. And I think that virtual hearings are here to stay. Whilst there might have been, a need and this during post-lockdown, I think they're here to stay now. And I think the skills that are required for virtual hearings aren't the same necessarily as those that are conducted face-to-face, because there's a lot that face-to-face contact, presence, and the physical presence of people bring, especially from an ethical and professional perspective, which of course absent when it comes to speaking to someone on the screen, and that requires a different skill set. So yes, we are looking at opportunities, we're looking at the skills that are involved in virtual hearings, not just virtual hearings, but hybrid hearings, and as well as concentrating on the skills that are needed for face-to-face hearings as well. So I think it's incumbent upon any education provider to A, keep its finger on the pulse, and B, look at trends, certainly now and in the future, and to respond with education and training needs continuous professional development. So we are looking at what skills will be required given the times that we live in, and how hearings and other things are going to change, especially in the world of practice. And we are sort of investing in new skills courses at the moment.
So thank you, Remy. As an arbitrator, handling these virtual hearings, are there particular things that bother you as far as counsel is concerned in how they are cross-examining witnesses? Oh, you're muted.
I'm sorry. I'm not sure there is, for wearing my casket, my cap as an arbitrator, but as counsel, I think the one thing that I think is really suboptimal in a virtual hearings is the added difficulty that you have with interacting with your co-counsel on your team. I know that some lawyers take a very a passive approach to hearings, where you have a lead counsel that's monopolizing basically speaking time and everybody else sitting bored in the room. But if it's not your approach to hearings, if you are part of a team that really works together to constantly shift, your cross-examination outlines, etc., and collaborate with each other, not being in the same room is difficult. You can use WhatsApp, you can use other chat systems, but it just doesn't quite replace being all seated on the same side of the table. So that's more of the issue, I think. But otherwise, I think you're right, Marike. We've seen virtual hearings becoming completely standard in the past year, and I don't think we're really going back. I think a lot of we've had the Queen Mary survey released recently with the White and Case Queen Mary survey, and I think there will continue to be an appetite for virtual hearings going forward. And so that means that adapting to that, including through learning advocacy in virtual hearings, will continue to be important going forward.
Thank you. I mean, this is very interesting. We're trying to use our crystal ball because we're still in the middle of it. We don't know. I mean, it also really, I think the saying goes, may it please the tribunal. And in this case, you really need to know who your arbitrators are. Some arbitrators are absolutely paralyzed by the technology part of it. And this is more draining, obviously. As Alexander says, you have to listen, and now you're listening to these screens. I mean, we're all exhausted after an hour. I think the participants are. So I'm looking at the chat. I'm very, very happy because other speakers, people from CERB, and also participants are answering each other's questionnaire, and there's a very interesting conversation also going on the chat. There are questions about, or actually positions on how good virtual hearings are, and there are questions about blockchain. Now, blockchain is a new thing. When we started that thing, we were not predicting the global pandemic. We wanted to take our time. There's a question about, is a blockchain award enforceable? Now, New York Convention, I kind of know that topic a little bit, and I can tell you that actually when it comes to Article 3 and 4 of the New York Convention, a blockchain award is much easier to enforce, and you will have lesser problems. So this is actually one of the big advantages of opting for blockchain, and maybe we just need to add it. Now, I just want to, we have 5 minutes to go. This is a very exciting hour because everybody is very active. I think that we need to find a way to continue this dialogue. We're talking about technology, we're talking about the pandemic, we're talking about mediation, we're talking about training. What I would like to do in the last 5 minutes, I want to just, because since we're talking about blockchain, Remy, I want to stay with you for 1 second to talk about artificial intelligence, because since the questions are very much focused on how should we shift gears, do we need to become more knowledgeable in mediation? Do you think that actually what is expected of lawyers and those who enter the field, maybe what's going to be expected of them will be different because of artificial intelligence? Is that true?
Yeah, I think it's a fair assumption to have that the use of machine learning, artificial intelligence is going to change or has changed already the way that we do work. To give you an example, I did a large case last year where we had a very large volume of documents that was exchanged by the parties in the context of document production. It was an ICC arbitration, and we used a vendor to manage our document management process, which had some very neat machine learning features, and that allowed us to prioritize, if you want, and put at the top of the review list documents which the system was learning were most likely to be relevant to us. And that allowed us to avoid missing crucial documents, but also it sped up the process and it made it less costly. And I think all of these, technological advances are going to change the way we work. When I started only about over 15 years ago, we had to spend hours upon hours clicking through documents and also even spending physical time in data room, going page by page through folders. And the economic model of law firms was very much based on this use of entry-level lawyers, if you want, and the gearing or leverage that you have as a company if you're able to allocate a lot of young lawyers to do that work. And I think if we're going to do less of that work, it means law firms are going to have to change their business model. They're going to have to make money not by throwing associates at cases, but by taking risk with their clients, success fees basically, and having smaller teams. And young lawyers are going to have a lot more fun because they're going to be doing less of this document review work. That being said, it means also that there will be less of a need for lawyers. So there'll probably be less jobs, but there will also be new jobs, I think. In my firm, Molo Lamken, we have Discovery Counsel. These are lawyers who specialize in document production. They don't do the other things that associates do on cases. All they do is really master the law and practice of document production, including issues of GDPR, et cetera, the relationship with vendors. And so these are new jobs that didn't used to exist before, and they're going to be more of these new jobs. It might not compensate the volume of young lawyers who will no longer need to be hired to review documents. So all of this to say technology is definitely going to change the way everybody works, from law firms to lawyers.
And you know what, Remy and Nadia and Paresh and Alexandra, we are now kind of feeling old because there's social media and there is blockchain and there's things that we did not grow up with. And now we have, we had a lot of people registering for this event, a lot of people attending who are already ahead of us when it comes to this new virtual space. But look at our children who spend their days on iPads and PlayStation 4s, and they will wear Oculus Rifts, and maybe we're going to virtual hearings with these Oculus Rifts, and God knows what else those terrible people at Facebook are going to invent. Now we have 3 minutes left, and I want to give all 4 of you your gorgeous closing words of wisdom, which is maybe for Alexandra, I love my life. I want to be counsel forever and come to Canada to join our young organization. Maybe Nadia has a takeaway as a client, focus on magic words mediation. Paresh on training, get out there, as Albert Jan says, get your feet in the mud. Remy, you wear all these hats. Maybe you want to say what your favorite hat is. So I'm going to start with Alexandra. Go ahead.
Okay, I'm going to give one key takeaway just about virtual hearings since we were talking about it. There's 2 big benefits I think you get from virtual hearing. First is there's a level playing field when you're in a box giving your virtual presentation. There's so much spoken about the art of advocacy and how taking up physical presence and space in a room benefits you doing a cross-examination because it makes you more intimidating. For all the women out there, I think that's something that virtual hearings can be beneficial for because you're suddenly on an even playing field physically. The second thing is virtual hearings increase access to justice. You can suddenly have those smaller value arbitration cases go to arbitration because you don't have to fly everyone to New York, pay for hotels, pay for the arbitrator to fly and travel all over the place, and you can get to a hearing much faster if people aren't traveling all over the world. So I think there's some hope and some positive that can come from that change during the pandemic.
Thank you, Alexandra. Nadia, what is the magic word for anyone who wants to make a client happy? Not lower your something else.
No, I guess the one is to be more commercially minded. think outside the box and think of a practical solution. So not what the ideal solution would be on paper, but what would actually benefit the business, enable the business to carry on, reduce risk, minimize costs, or maintain the relationship that you already have. How can you repair the relationship? And sometimes you start off with the arbitration, but then parties eventually come together, sit down around the table, and they hammer out a negotiating agreement, and then they can carry on. So think of ways that you can actually solve the dispute. That is the key, how to solve the dispute. And that doesn't mean that it has to be exclusively mediation, negotiation, arbitration, litigation. It doesn't have to be in that order. It could be a combination of all four of these things. And that's what you always need to ask yourself. What is in the best interest of the business? What are you trying to achieve?
Then Remy, what is your favorite hat? You can only pick one.
So I can't pick, because I really think that if you're passionate about arbitration, if you really love the subject matter, you want to see it from every single angle, and that's arbitrator, institution, academia, practitioner, etc. It's very hard to choose.
You want to have the high top hat. That's what Remy, we're going to visualize Remy with the top hat. Now, Paresh, if you would have to choose the next course, the next webinar, which topic are you going to pick? It's going to be mediation, technology, blockchain, artificial intelligence. Tell us.
Gosh, there's so much to choose there. I think that cybersecurity will be a key thing. I think that right now, because data has been increasing year upon year, especially it's double, treble in the last decade or so. But I think we're going to see a lot more emphasis on data in the coming years. And the importance of data is just going to, it's always been important, but it's going to be ever so more important. And it's important that, but from a professional, ethical, and other perspective, that people, of course, keep data secure. So I'll focus on cybersecurity.
Thank you. Well, I'm only 1 minute over time. A proud Dutch person, like my mother in the Netherlands, would be really happy. Our four speakers have been absolutely amazing. As far as I'm concerned, I think you are amazing. Great attendance, great conversation on the chat, great conversation on the Q&A. I am very happy. Signing off, but before we do, we want to thank the speakers, but we also want to thank the fact that we're part of the London International Disputes Week, that we worked with the young arbitrators in Canada, teamed up with Queen Mary, and obviously, Paresh, CRP, you're doing amazing work. This is going to be the future. And then a final thanks to all the participants that you do this despite the Zoom fatigue, and that you make the effort of asking these questions and being in the chat. We're really, really grateful, because the success is only because of how you participate. Thanks to all, and good night. And as we say from the TV, Godspeed. Goodbye.
Thank you.
Thank you.